Bill Henshaw here again, another one of my YouTube videos on current events. And this will be a little departure from the COVID stuff I've been driving at so hard and the murder of George Floyd. As a lot of you that watch my videos, the new ones and earlier ones on my YouTube video, you've heard me talk a lot about Republican form government. That's a huge, big deal. And yet it isn't clear, at least at first blush, as what the hell that means. And yet Article 4, Section 4 guarantees to the states a Republican form of government. Basically what that means, the essentials are that we have local control. Most of the power is at the county level where it should be. Much more efficient, much less costly, and much easier to talk to our representatives when we need to invoke our right to instruct them when necessary and get results. Also, it means you have a lot of responsible parties, and you try to find those in the military government we have these days. Ain't not going to happen. We have responsible parties on the local level that can be dealt with. If nothing else, you vote the bastards out of office in real elections that mean something. Not what we have today. We haven't not had a ballot election here since arguably 1867 in the United States, after the ratification with a capital RAT of the non-existent 14th War Amendment. The states all got converted to territories, although they didn't bother to tell anybody who ratified the amendment. That's what they were doing, the secret committee of 15 on Reconstruction. And in territories, there's no elections unless provided for by Congress. Conveniently for them and the New York banksters, Congress hasn't passed such a law. You ready for this? August the 14th, 1848, the Oregon Territory. There are no elections. Okay, officers in territories are either required to be appointed by the president, Article 2, Section 2, the Appointments Clause, or a territorial governor appointed by the president. And that's a big way for us to beat these badgers. We're going to go in there and start demanding they produce certified copies of their appointment to office, and they ain't got one. You're out of there. No authority. That's a structural jurisdictional error. And I've got an 82-page brief that you can get with my modestly priced constitutional defense document packets on the subject of admission of new states. You know, that beats them across the board. No one's ever attempted to oppose it at all. No local dumbass, nothing. So like I say, send me an email, youwinnincourt@gmail.com. I'll get the information out of the materials and what I have. And while I'm thinking about that, I've got a new COVID packet too for all this crap going on here, especially with previews of coming attractions. They're going to be going door to door. The federal military, needles and bazookas in hand, to offer you a free, albeit compulsory, COVID vaccine. And your children too, which raises the immediate question is, whose kids are they and why? If they're not your kids, that's what they think. And I can prove to you that's what they think and why they think it. Get my materials, read them, study them. You'll get this. They're their children. I mean, they're their citizens. We know they're a nice way of saying slaves. They own them, lock, stock, and barrel. That's the way it works. There are no rights the de facto National Socialist government is bound to respect. If you're in that system, see you later. Now, they can do that with artificial corporate entities. Those are privileged to start with. And that's the other thing with the 14th Amendment. It made citizens out of corporations for that purpose. And yet that's the only jurisdiction they see in their corrupt courts. But getting back to Republican form of government, among other things, it means, and it's simple math, fourth graders are going to get this if we get any of those in a jury, if you ever happen to get there, which I'm never going to be allowed close to one. But you just point out the fact, Article 1, Section 2, Clause 3, how's that? 1, 2, 3 states the maximum ratio of representation is one representative to 30,000 inhabitants. If you do the math today, we would be required to have over 10,000 members in the House of the Representatives. What do we have? 438. Doesn't work. Every law they pass is unconstitutional on that basis alone, even if otherwise within the ambit of the powers they have under Article 1. And no racial representation, the same thing, especially true during the Reconstruction period after the war between the states, when the southern states who had been recognized and Congress presented the 13th Amendment to those state legislatures that had been set up by Lincoln and then Andrew Johnson following his untimely assassination, and to get their approval to end slavery. So they clearly recognized that those states were back in the Union. And yet when elections ensued in 1866 and they tried to send senators and representatives, well, senators are appointed by the legislature, but none of them were admitted. Therefore, no racial representation, especially with regard to proposing amendments. And the 14th and 15th wouldn't have even been proposed, let alone sent out to be ratified, if the southern states had been there where they belonged. So the Republican bit, like I say, is very important because you have that, and you then take a lot of power away, particularly from Washington, D.C., where it isn't supposed to be in the first place, and even state capitals, and especially a big deal in California, because out here we have 40 million people in California, and we have 80 in the California Assembly. Do the math. That's 500,000 to 1. That's nothing close to a Republican form of government. Now, maybe the number doesn't have to be 30,000 as set forth in Article 1. That's a debatable object, but 500,000 to 1. What does that do? Makes it more expensive for people to run for office who otherwise might do so on a local level, and makes the 80 that they have in Sacramento a hell of a lot easier to control by the artificial corporate entities that put them there. The insurance companies, the law enforcement thugs, the state bar association. This is not a Republican form of government. It's not even close, and for those reasons. And also think about this, if you want to run for office, it'd be much less expensive to do it in a much smaller geographical area. More people would be inclined to do it and get involved. And that can't be a bad thing. So that's what we want to see a lot more of here. And then it makes it, and when you do that, you don't need corporate backing to pay for your election expenses and this, that, and the other. So you're not beholden to them. You have the interests of your people in your district come first, and that's the way it should be. Simple, nothing hard about that. So, and like I say, especially important with Congress, not only with what I just said about 10,000 plus members, but now Congress, thanks to the 9 parts, are you paying attention, John Roberts? They had a exponential expansion of Congress's Commerce Clause powers back in the 1930s, the FDR New Deal, which they didn't bother, had a deck of 52 jokers. And what happened was the Commerce Clause powers were expanded so far as to just about do away with the states, even if the 14th Amendment hadn't. Everything is now commerce. And almost all of the crimes they charge, quote unquote, crimes are commercial. That's 27 Code of Federal Regulations 72.11 for those of you interested to look it up. In fact, you send me email to request information at uwinnincourt@gmail.com. I'll send you a copy of that CFR. And you'll see it. And the big deal here is that commercial crimes, quote unquote, the Commerce Clause powers of Congress, the 9 parts have ruled, is intimately connected to the Admiralty jurisdiction. For those of you that don't know, and most of you probably don't, that was a central cause of the American Revolution. And yet here we are. But better for us is Article 3, Section 2 flatly states that Admiralty is vested solely in federal courts. There isn't a state court that can exercise it. So the first question you ask when you get in there, and with my paperwork, you'll know how and when to do it, is basically ask the judge, where the hell are we? For a Commerce Clause powers, and you're a state court, we've got a real problem here. You're acting coram non judice. That means not as a judge, and you're personally liable. Not only that, the judge, quote unquote, might be committing acts of treason, again, according to the U.S. Supreme Court, as you'll learn. Now, this is so simple. The first thought is, why the hell don't attorneys do this? They're in the game and up to their necks. I mean, they belong to the State Bar Association, British Accreditation Registry, And they may well be foreign agents because of it. And if they are, they're required to register as such under the Foreign Agents Requirements Act. That's another thing we approach with some of the documents I do. They're not going to do it. Because if they do that, that's the end of their career, and it might be the end of a whole lot more to blow the whistle on your lodge brothers, to do that and expose all the corruption that's going on here. These courts don't have any damn jurisdiction. I don't care what it is. If they're quote unquote state court, they don't have it. They can't have it. By the way, throw in the mix here Section 9 of the Judiciary Act of 1789, too. They don't have it. It's that simple. So what that tells you is that we're in federal territorial tribunals, not state courts. That's a winner chicken dinner. There's no way around that. Even for Warren E. Berger, who's the worst justice ever on the court, I think even he would not be able to overlook that one, although it never came his way in the 16 years he was on the court. So there's a lot to this Republican form of business, government business, that you need to be aware of and how it works, how it should work. And like I say, it won't be perfect when we get it back, but it'll be a hell of a lot better than what we have now. And I think the best government ever devised to this point. Maybe we'll see a better one in the future. I don't know. But if we get this one back, life will be a whole lot better for all of us, for you, your children, your posterity. That said, send me an email, unincourt@gmail.com, for information about my materials. Like the videos, tell your friends, subscribe, get the word out. The more of us doing this, the harder it's going to be. I mean, they can't say no to all of us without admitting there's no Constitution. And there hasn't been, by the way, since March 9th or so, 1933. Good old FDR suspended it along with Congress. But it's still there. It's not been overtly suspended. That's another thing, by the way, I'll send you complimentary with the request for information. It's a thing called Essays on Emergency Powers, Senate Report 93-549. And they were complaining about this in 1974, having been 40 years in a state of perpetual emergency, one after the other. Here we are 45 years later, nothing's changed. If anything, it's gotten worse. But you read this report, it'll tell you why. So send me that email and, we will get it out to you and information on my materials so you can learn and teach your children, because they're not going to get taught in school either. So as I said, that's it. Like the video, subscribe, tell your friends, get the word out. Thank you.